Welcome once again to Lehto's Law. Here's Steve Lehto.
Brian tipped me off to a story he spotted in the New York Times, and I actually had already read this, and I was thinking about doing a video about it, and I'm going to now because I think it's an extremely important topic, and it touches on something that kind of bugs me. And I'm an attorney, I've been practicing law for 30 years now, but even before I was an attorney, I was always bothered by the idea that prosecutors want to win the cases and defense attorneys want to win cases. And it gets to the point sometimes where nobody really cares about what actually happened. So whenever I see a former prosecutor turned talk show host bragging about their win ratio as a prosecutor, my first thought is, oh, you put some innocent people in jail, did you? And if you didn't, you were cherry picking the good cases. But the question now is, as Emily Bazelon writes for the New York Times, did Tennessee execute an innocent man? And it's a question that we have to ask. And it's strange that we don't know the answer. And it'll all make sense in a second. But many people on death row, of course, have gone to their death protesting their innocence. In at least 12.5 cases, strong evidence suggests that these people were in fact executed despite the fact they were innocent. So far, no case has emerged yet in which DNA or other evidence has provided definitive proof that the state actually did execute an innocent person. So it's something that people have thought about, but no one's proved it just yet. So some people, like from the Innocence Project, have pointed out that if such a case ever existed, it would actually cause a lot of people to rethink the death penalty in America. So a lot of people are now looking at the case of a man named Sedley Alley, who was executed for a 1985 murder. Now, the man's been executed. He's gone. He's gone. But at the time of the killing, DNA testing was not yet part of criminal investigations. After the technology became widespread, a state appellate court refused Mr. Alley's request for testing of clothing and other items found at the crime scene. In 2011, the Tennessee Supreme Court rejected some of the lower court's reasoning in the Alley case, but the problem is it happened 5 years after the man was executed. And this is what I do not understand, and I've yet to hear anybody actually give me a good explanation for this. So I'm going to pose the question to you. If a man has been convicted, or a woman has been convicted and is rotting in jail, and someone comes forward and says, you know, there's a potential that DNA evidence that was not tested at the time of the trial, if it could be tested now, it will definitively answer the question, did this person do it or did they not do it? Why do prosecutors object to that? Do they know the person's innocent or they don't care? Because if that person really did do it and the DNA would prove it, then you'd want it tested. And I've mentioned before, I wrote a book about a guy named Timothy Masters, with Timothy Masters. We co-wrote the book together. And he spent 10 years in prison for a murder he did not commit. And there was DNA evidence that they could get from the crime scene. But when he was put on trial, they didn't have the technology just yet to do this. And also part of the problem was he was put on trial so far after the crime. After he'd spent some time in prison, he finally managed to get a hearing on whether or not they could test for DNA that was found at the crime scene. And the prosecutors fought that, as they say, tooth and nail. They fought that. They absolutely, and so Timothy Masters had said that he had never touched the woman in question, never touched her. So if someone comes forward and goes, look, we can get DNA off of her clothing from the perpetrator, and there's other things that we can test, if they could find a trace of Timothy Masters' DNA anywhere on her, it would have shot a hole in his story, and it would have been like, oh, guess what? But they fought it. And it makes you wonder, because when the court ordered the testing all came back someone else. It was not Timothy Masters. And once the testing came out, everybody's all, oh, weird, okay. So they let him out of jail. And the weird part is that you see this all the time. Someone's rotting in jail. Someone goes, oh, by the way, do you know they actually have something with DNA on it that we think would be tied to the person who did this, the perpetrator? Let's test it. Prosecution objects. No, don't test it. Why? Are you that interested in winning that you don't want it tested? That to me does not make any sense. You've heard the saying that courts are a search for the truth. A search for the truth. The fact that prosecutions routinely object to to testing DNA proves to you they do not believe that courthouses are a place where you search for the truth. It's not true. So the question is, will DNA testing that could prove Mr. Alley was innocent, will it be allowed? That's what this case is all about. So there's no question that a woman was killed in 1985. Navy investigators picked up on this defendant and charged him with the crime. I'm not going to get into the facts of the crime because the facts are kind of convoluted, but the point is that there really wasn't a whole lot tying him to the crime as far as physical evidence goes, okay? So in the years following the man's sentencing, where he's sentenced to death, the use of DNA analysis by law enforcement became more common, increasingly important for solving crimes, and also for calling into question past convictions. So DNA evidence has led to the exonerations of 21 people who served time on death row, according to the Innocence Project. So it freed some people who were innocent. Now, I've had other people point out the obvious thing, and I often, unfortunately, skip this, is if you've convicted the wrong guy and you refuse to admit it's wrong, the real perpetrator is still out there somewhere. So you're doing two things wrong. You're letting the real guy get away, and you're punishing the wrong person. In 2001, Tennessee passed a law broadly instructing its courts to grant access to DNA testing if a petitioner could show a reasonable probability that he or she would not have been convicted in light of the DNA results. Mr. Alley and his new lawyers soon went to court and asked for analysis of the crime scene evidence. They argued in part that running that evidence through a public database might identify the real killer. So in other words, if they find DNA evidence at the crime scene that doesn't match our guy, they can probably run it through a database and find the real guy. And if you find the real guy, my guy didn't do it, right? You think so? Well, the Tennessee Appeals Court rejected that request, saying that he had failed to establish that reasonable probability that he would not have been convicted. The court also rejected the argument for the crime scene DNA to be run through a public database to identify the real killer. Again, are we searching for truth here or not? In a bizarre reading of the law, the appeals court said the law's reach was limited to comparing the defendant's DNA with samples of clothing and other evidence. The purpose of DNA testing must stand alone, the court said, and does not encompass a speculative search for the possibility of the perpetrator. In other words, Mr. Alley was barred from DNA testing even if it would exonerate him by identifying the actual person who killed the victim in the case. And that would be the victim that he was accused of killing that put him on death row and eventually led to his execution. So the man had a daughter, and she is now pressing for this to happen. She wants this testing to take place. And there are now people saying, well, why are you doing that? The man's been executed. There's no purpose in this. And do you have standing to do that? You know, if he was here, yeah, but he's not here anymore. So Ms. Alley, the daughter, has renewed the petition for DNA testing in her father's case, and her father's life cannot be saved, obviously, but she thinks maybe his reputation could be. Meanwhile, the district attorney in this case opposes the request for DNA testing, but declines to comment when called by the author of this article. In a legal brief, the Tennessee Attorney General's office argued that attacks on criminal judgments end with the death of the prisoner. So the legal team argue that it is unconscionable, given the history of the case, for prosecutors to oppose DNA testing on the sole grounds that they have already executed the defendant. And the state makes that argument, and I, as an attorney, I write things for the court, right? I write a brief for the court. So I'm going to go and argue something in front of the court. I write a brief to explain my position. I go in and I make an argument. And I'm writing it for the court. And I very rarely think, what would other people think if they read this? No one ever reads my briefs except for my opponent in the court. And I always wondered, though, when somebody like this, the Attorney General, State of Tennessee, writes a brief, and they know this case is a high-profile case, and they know that other people might read the brief. And here we are in the New York Times reading their brief, portions of it. And they say, you don't have to test this DNA to see if this guy's innocent or not, because he's dead. We've already executed him. Game over. I would think an attorney general, at the very least, should say, you know something, we don't have an interest in this case anymore because we've convicted somebody, they've been executed, and we believe we got the right guy. But why would they oppose the testing Why? Why don't they just go, you know something, we don't have a position on it anymore. We don't have a position on it anymore. But they won't do that. Instead, they oppose the testing. They dig their heels in, as they say. Why? And here's another problem. If executing the person closes the case, the state now has an incentive to execute people faster. Because these appeals just drag things out. And if the appeal somewhere down the road might get the guy exonerated through DNA testing, if we execute him tomorrow, well, they can't get testing the day after because he's dead. So there's a couple policy reasons why they should allow the testing. But the biggest policy reason should be that we're trying to find out the truth. We want to know who actually killed the victim, right? I've had people say, Steve, you know something? Once in a while you argue this obvious stuff, Captain Obvious type stuff. You argue these things that are so plainly apparent. 2 + 2 = 4. Why are you making this argument? I feel I have to. Because I think that when someone makes an idiotic argument, you have to call them out on it and say, I don't understand why you're making that argument. There seems to be a problem here, a disconnect. Why would the state not be interested in knowing who actually killed the victim who died in their state? And you can't say, we know who did it because a jury found this person guilty. Juries make mistakes. And so we have situations where, and I'm not saying this necessarily in this case, but it looks like it could be in this case also. We have situations where there's DNA evidence that if you could tie this DNA to this person, they're most likely guilty. And if you can't, then it ties to somebody else that somebody else is probably guilty. That seems pretty straightforward to me. So again, the Attorney General, for whatever reason, takes the position that no, we make no mistakes. We convicted somebody, it's game over. We're done. We've moved on. We've moved on to their lives. And as pointed out, they've documented 21 examples of people who are on death row, exonerated by DNA. Story I told you about Timothy Masters. No question he didn't do it. And they have DNA of somebody they think did. But up until the testing was done, the prosecutor's office took the position, no, we do not need the test. We do not want to test. We oppose the testing. We object to testing. The testing should not happen. Why? Why? You know, so the idea that you're searching for truth, or trying to find justice, goes out the window when you say we don't want to do this testing. For fear it will show that we made a mistake. Because that's what it really boils down to. And so next time you see someone on TV and they're hosting a show or they're a guest on a show, I'm a former prosecutor. I was undefeated as a former prosecutor. Undefeated? It's a game? It's not a game. And the people who say that, by the way, I know prosecutors. I've had students of mine who became prosecutors. And they will tell you that cases cross their desk all day long, good ones and bad ones. You can't win them all. And the ones who do win them all are cherry picking. They're grabbing the easiest cases, the low-hanging fruit, or they're convicting some innocent people. Take your pick. So it's nothing to brag about. Your job is not to win every case that crosses your desk. Your job is to get convictions against the people who actually did it, and to not get convictions against people who either didn't do it or you don't have enough evidence to prove that they did. So that's a problem. So here we have a situation out of Tennessee where it looks like Tennessee may have executed an innocent man. Some people would like to prove the point, and the prosecution doesn't want that to happen. My biggest question here is why? Why do they not want that to happen? So there you go. Brian sent me the article. Emily Bazelon wrote it for the New York Times. It's an opinion piece. Did Tennessee execute an innocent man? Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Don't sweat the petty things, and don't pet the sweaty things.